Hence, again, constitutional coup out here in California. One of my first videos of the new year, and an important one for those of you dealing with these bastards known as homeowners associations. And you're going to love it because they don't have any right to exist at all, and certainly they can't compel you to join one. And you'll learn we have multiple issues, rights arising from the Constitution that prevent that from happening. Among others, the fact you have an unlimited power to contract, Article 1, Section 10. So, that immediately comes into play. And we want to shut these bastards down. What I've seen, they think they can do any damn thing in the world. They can fine you for work you've already done, for example, that was quote unquote substandard or what have you. I mean, there's so much crap here with this that goes on, and I think they can do it all by regulations without any need to appear in any administrative tribunal, let alone judicial court. And that in some cases they can levy fines on you and use those fines as a basis to foreclose on your real estate. Well, that's where you really have to understand what's going on because, it may be that you bought the house, but you don't own it. That's why they can do it. All you have is an equitable interest. And like the justices of the Supreme Court said back in the day, and they were much more oriented towards original intent, by the way. This is a bit embarrassing. And I bet you the justices on the court now know this case. It's right next door to Collins v. Virginia back in 1818. Best decision they ever made, and the justices are all over it today. Other case, Bank of Columbia v. Oakley. And Oakley ran into some trouble managing his farm, couldn't pay the loan, and the bank wanted to foreclose. And he goes in to the trial court and says, "Not so fast, I have a right to trial by jury." Back in the day, you did, and they agreed with him. Goes on appeal to the Circuit Court of Appeals. He makes the same argument, gets the same ruling. Now we arrive at the U.S. Supreme Court. That's why it's called Bank of Columbia v. Oakley. They reverse. And to be sure, I would like for them to have said the real reason, but maybe in 1815 they couldn't have anticipated what's going to happen in the next 200 years here. But they said, in effect, when you took out the loan at the bank, you became a hypothecator of goods or stipulator in the admiralty. 8. No right to trial by jury. They reversed. And as far as the official records go, it looks like he lost his farm. Now, back in the day, and remember, this is an era where a lot of people grew up. A lot of the Constitution was coming into effect, and the Declaration of Independence and education on these subjects was much better. They might have presumed in that era he should have known the conditions of the contract, and I can't find anything in that case that says that the bank made a full disclosure. And that's a major jurisdictional issue that we have today in other settings as well. If they don't tell you, you can't be presumed to know, especially now since they presume all of us are incompetent. Back in the day, it was the opposite presumption and should have been presumed competence and that you would know what you did. So I'm not thrilled with that in the long term, but I simply think the justices couldn't have foreseen what we're dealing with today. But that's the big deal. And the same thing with the Homeowners Association. They have not made a full disclosure, which they're required to do. And if they did that, you would learn, by the way, they're not even registered to do business anywhere. We'll be talking about that. By the way, for information, send me an email, youwinnincourt@gmail.com. You won't believe the amount of structural jurisdictional errors that we have to make against these bastards. It's that good when you know what you're doing. And no, I didn't come out of high school all those 60 years ago either. They didn't teach me a damn thing in this area back in the day and outside of Washington, D.C. for crying out loud. But I learned. Loved to have known all this at the time. I could have got a head start and maybe gotten the job done long before I even started to. But that said, if you don't know, and today they presume all of us are incompetent. competent, a video for another day, there's more of a duty to make a full disclosure now, isn't there? But if they do that and you find out that you paid for your property, quote unquote, your property, and you did it by using undefined Federal Reserve notes, only defined, if at all, by the president acting as commander in chief of the armed forces. That, as a matter of fact, all you've done is discharge the obligation. The debt is still due. That's why they think you don't have any property rights. But the problem with that is, our Federal Reserve notes represent our property in the form of our time and labor. But that's not seemingly recognized today. The Internal Revenue Service operates on the principle that a taxpayer has a zero interest in his time and labor. They think they own all of us, or it looks that way. And you'll find out more about why that's not true. Send me an email, youwinnincourt@gmail.com. But when you understand what's really going on, it's simple. Because that Internal Revenue Act of 1913 was and is a direct lineal descendant of the Corporation Excise Tax Act of 1909. You're a corporation, you're a taxpayer. No problem. You owe your existence to the de facto national socialist government. You have no rights that government's bound to respect. Sound familiar? Yeah, sure, that's what it is, but that's not the original intent of those racist framers. It's exactly the opposite. We did have property rights. Our lives had value, creator endowed with alienable rights. And look at what we did in about 125 years. Became the most powerful nation on the face of the earth. That worked. Was it perfect? No. Never has been a perfect government, but this was the best one ever invented. We want it back. We can make changes from there, do it right, and get back to our federative government, Republican form of government of defined and limited powers, and unload this. I can't think of the name right now, but democracy, for want of a better word, 3 wolves and 2 sheep voting on what's for dinner. Elective despotism. That's all it is. The elections mean nothing. You have no rights. They think we're all corporations. And the HOA is one of the worst examples of this homeowners association. And that's truth in advertising. They may own your home, but you don't. That's how they think they can get away with this. And we can stop them. And you'll learn how. I've developed some really great documents. One of them is the removal of the federal court non-statutory supremacy clause removal. Because the big deal here is if we become a hypothecator of goods and stipulator of the admiralty, no state court has subject matter jurisdiction. And they probably don't have personal jurisdiction since they can't make any lawful service process on you. Because whatever they do, they send you a summons. If they do it all, your name in all capital letters, with the CA out here for California and a zip code. That doesn't work. They've served you for all apparent intents and purposes in the District of Columbia. You'll learn a lot more about that one. Send me an email, youwinnincourt@gmail.com, because they think you reside in the District of Columbia, and everybody across the United States resides in the District of Columbia. Ain't not true. We are domiciled in a state judicial district. Service of process doesn't reach us there, and the Supreme Court has a powerful case about that called the Pennoyer Rule of the U.S. Supreme Court, Pennoyer v. Neff, 95 U.S. 714. And this was a long time before zip codes were around. I mean, they couldn't even imagine this in the 1880s. The zips weren't there until I was growing up in the 1960s. But that's what they're telling you. And if you're subject to the powers of Congress under the D.C. Clause, Article 1, Section 8, Clause 17, it's a lost cause. You don't have any rights. There simply aren't any there. And that's what we have to get around. And the justices on the court know it right now. They're going to have our backs on a lot of the issues I've been explaining here and more of them besides. And it'll make sense because a lot of you out there, especially if you purchase homes and you have money and a good job and some education, you'll have a clue here. There are some serious problems. And you're right. Instinctively, you know it. You go into one of their quote unquote courts, aka administrative tribunal, and the black robe bastard state bar attorney rules against you and in favor of the state bar attorney that's in there on behalf of the banks. You can tell there's something rotten in the state of Denmark here. But we have a chance to get rid of it right now. That's what's exciting for me at my age. 75, life is still ahead of me. And hopefully I can help you to reach the same conclusion and get your house back and get lawful title to it. And then it works with a lot more than the homeowners association. If that happens too, now there's no property taxes, there's no nothing. We're back to where we should be. And that's a hell of a leap forward. If I can get that done before I go out of here, I will have done the job I was put here to do, even if a bit late. But better late than never. And in my case, really late because I'm a refugee and I know exactly the date, March 3rd, 1857. You can Google it and you'll find out why I know that. But yeah, that's where I come from. I was put here to do a job and we're going to get it done. And it's exciting stuff. And to learn more, send me an email, youwinnincourt@gmail.com. Remember to subscribe, tell your friends, like the videos, get the word out. Thank you.